Okay, thank you. I want to welcome all of you to today's seminar, which we're going to talk about proposed rule changes and a little bit about the Jeff's e-filing system. On the panel today with me is in the center, Judge Jeanette Castagnetti, who is the First Circuit Civil Administrative Judge, and she is also the foreclosure judge for the Fifth Division and chair of the Civil Rules Committee. Seated on her left is Judge James Ashford. He is the trial judge in the 10th Division, also a member of the Rules Committee. And myself, Gary Chang, I am the judge for the 14th Division in First Circuit, and I am a civil trial judge as well as the land court and tax appeal judge. So we don't have a whole lot of time, so let's just get right to it. Judge Ashford, would you like to start us off?
Okay, thank you. So I'm going to talk about proposed changes to the Hawaii Rules of Civil Procedure. Judge Castagnetti will talk about proposed changes to the Rules of Circuit Court. So I may start talking about these things as if they've been adopted, but they have not yet. So they are all proposed, notwithstanding anything else I say. In general, I think that many of the changes are just stylistic or grammatical or whatever, and of relatively little consequence. There's not an enormous amount of substance to these. I'll talk about, I think there are proposed changes to 9 rules of civil procedure. I'll talk briefly about 7 of them. Those will be rules 1, rule 1.1, which is actually a new rule that's been proposed. Also rules 3.1, 5, 10, 11, and 72. I believe that you folks received copies of the proposed changes either when you walked in the door today in hard copy or electronically when you registered or got an email from the HSBA. Rule 72, which I will discuss only very briefly at the tail end of what I talk about, applies to agency appeals. So you don't have materials for that because they weren't part of the packet, but my discussion of Rule 72 changes will be relatively brief nonetheless. I also want to mention the Hawaii Electronic Filing and Service Rules. Those were adopted by the Hawaii Supreme Court 9 years ago. So they've been out there for quite a while. I assume that had to do with appellate electronic filing. So they've been out there for quite a while. Some of you will be familiar with those, some of you will not. But they have been around for quite a while. So if you're not aware of them, get familiar with them very quickly because they're integral to using the electronic filing system. Okay, with that being said, I'm going to numerically start with proposed changes to Rule of Civil Procedure 1. And I'm just going to go in the order of the materials that you folks have, so you're welcome to follow along with me. So I'm starting on page 1 of the material. Rule 1B provides that these rules shall be read and construed with reference to, and it identifies a whole bunch of rules, but it specifically includes the electronic filing and service rules. So I've already made good on my promise to refer to those electronic filing and service rules. More importantly, Rule 1E states that definitions are contained in those electronic filing and service rules. There are 15 defined terms in the definition sections of the electronic filing and service rules. And I'm just going to point to a couple of those now. For those of you who have the most rudimentary or maybe no understanding whatsoever of the electronic filing system that you're about to get engaged with. The first definition I want to mention is the term JEFS, J-E-F-S. Excuse me, and also JEFS user. So JEFS is an acronym for Judiciary Electronic Filing System, JEFS. So the JEFS filing system is a system that you're going to use to electronically file documents in GEMS. A JEFS user obviously is one who uses JEFS. It's defined as an individual with a valid JEFS login and password. But that's just really an introduction from my point of view to get people to turn to Rule 1.1, which I think is of more consequence. As I said earlier, Rule 1.1 is a proposed new rule. It's not a proposed change to an existing rule. But what's of importance here is that Rule 1.1 requires every attorney who represents a party to a lawsuit to register as a Jeff's user. So if you're an attorney and you're representing somebody in a lawsuit, you must, by this upcoming deadlines, you must register as a Jeff's user. And it also requires all attorneys to file all documents electronically. Okay, so with that said, the point of it all is that if you have a case in GEMS, and for this purposes, we're talking about October 7th for civil district court and October 28th for civil circuit court, you have to register and you have to file all of your documents electronically. As Judge Chang can get into it more, I don't think, is there any grace period, Judge Chang?
No grace period.
So you're falling off a cliff on October 7th if you're in district, October 28th if you're in civil. Rule 4.1 of the electronic filing and service rules does allow your staff members who are employed by attorneys, as long as the attorneys to be Jeff users as well, they can register as Jeff users on their own and they can file documents electronically for you. So my general sense as I look at the crowd here is that we have attorneys and there might be staff members, but if so, they're very few, but you can have your staff members register themselves. Of small note is also the fact that Rule 4.1 of the electronic filing and service rules states that pro hoc vice attorneys cannot register as Jeff's users, and that's because local counsel is responsible and in charge, and therefore the local counsel will be doing all of the electronic filings, not the pro hoc vice attorneys. So bottom line, once October 7th rolls around in district, October 28th in circuit, you're not going to be filing documents the old-fashioned way any longer, and you're not going to be serving them, at least on other attorneys, the old-fashioned way any longer. And for what it's worth, old-fashioned is defined more specifically in the electronic filing rules as conventional filing and conventional service. The point I'm really trying to drive home there is that the electronic filing rules that have been around for 9 years have a lot of definitions and procedures that, although they're not part of the proposed rules that we're here to talk about today, I think you really need to be aware of the electronic filing rules because they work hand in hand with the rules and the operations that we'll all be talking about today. Okay, next point I want to make regarding Rule 1.1 is that it does not require that pro se parties, who are now properly called self-represented litigants, but some of us still say pro se, so I will probably do that today. But it does not require that pro se parties register as Jeff's users and that they file electronically. So if you have a self-represented litigant in your case, you're going to be sort of operating under two different standards, so to speak. You deal with the attorneys who must be Jeff's users, you deal with them electronically, and potentially and probably you'll be dealing with a self-represented litigant conventionally. But Rule 1.1 does say, the last sentence of the proposed new rule, that is, that self-represented litigants may register as Jeff's users if they choose to do so. So depending upon the individual, you may or may not have a Jeff's user as a pro se. And so that's something you're going to have to be aware of. Bottom line, if you're an attorney representing somebody, come October 7th, October 28th, get used to the electronic world because that's the world that you're going to be compelled to be living in. Okay, so I'm going to move on to Rule 3.1. Very briefly, frankly, historically, Rule 3.1 required the submission to the filing clerk of not only the original complaint and other affirmative pleadings, but also copies of those. With electronic filing, hard copies are not going to be the law of the land anymore, so to speak. So once a document is electronically filed, copies are easily obtained, so you don't have to do that. Same thing goes for the civil information sheet, which now will be electronically filed, and no hard copies need to be filed. In my view, since we're generally, well, I won't volunteer that unnecessary comment. I think that's the substance of Rule 3.1, though. Okay, moving on to Rule 3.5, and I'm not going to be talking about the portion of it that's on page 2. Instead, I'm going to be talking about portions on page 3 and also page 4. So the first thing I want to comment on is really at the top of page 3 of your materials, very simply, where a non-Jeffs user is involved, such as a self-represented litigant, serving by fax is no longer allowed. So facsimile is out the door under these proposed new rules. Second point I want to make is in the middle of page 3 under subparagraph B3. B3 of the proposed rule states that service via electronic filing is complete upon electronic transmission. So once a document is electronically filed, service is complete on all Jeffs users. Again, if you have a self-represented litigant who is not a Jeffs user, you have to file or you have to serve conventionally. But you have service via electronic filing is complete as soon as it's accomplished, meaning the filing. Okay, the third comment I want to make to proposed changes to Rule 5 is on the next page towards the top, page 4, subparagraph E provides that proposed findings of fact, conclusions of law, as well as proposed orders and proposed judgments will no longer be lodged via hard copy with the judge's chambers. Instead, as provided also in Rule 9.1 of the electronic filing and service rules, those documents will be marked proposed, quote unquote, and are to be electronically filed. So it's just another example of how we're moving to electronic lodging, shall we say, or filing, as opposed to the conventional or old-fashioned way. I'm going to move on to Rule 10 very briefly. This is pretty minor in my view, but the bottom line with the proposed change to Rule 10 is that you have to leave 3 inches of space at the top of your pleadings, either by doing that just across the board, everything in the top 3 inches, the whole thing will be blank, or at least leave a 3-inch by 3-inch square, so to speak, on the upper right corner when you file. That's to accommodate and provide space for the electronic file stamp to be placed there. The next comment I'm going to make is not actually in this rule, but I'm going to offer it nonetheless. The current rules already provide that you have to leave a 1-inch margin at the bottom of your document, and you should continue to do so because from what I've been told, and again, this might be Judge Chang's area, but when you want a certified version of a document, the certification is going to go in that bottom 1-inch margin. So much as you might want to cram more words into a document and err on the side of brevity or smallness on the 1-inch margin, you need to leave that open because that's where there might be a certification. Okay, moving on to Rule 11. Rule 11 states that electronically filed documents shall be signed as provided by Rule 5 of the electronic filing and service rules. So that takes me to Rule 5, which in turn provides that the signature of a Jeffs user shall be /s/ and then the name, such as /s/ James Ashford. That's going to be put in the space where you would normally put your handwritten signature. The rule also provides that where a third party would typically sign a document, such as a declaration or an affidavit, someone who's not a Jeffs user is going to be signing your declaration, or his or her declaration rather, for your support of your motion or whatever it might be. In those instances, you have the wet ink signature, so to speak, hand signed, and you PDF that and download that. So if you're the Jeffs user /s/name, if it's an affidavit, declaration, or other document, whatever that might be, then you use the ink signature, you download that via PDF. And I believe that the instruction that people are getting is that, although I don't know that this isn't a rule, is that you need to put your complete first name and your complete last name. So it can't be J. Ashford, it's got to be James Ashford, or whatever the hopefully other name will be that's being submitted. Okay. The next thing in the materials is Rule 30. I'm not going to bother to talk about that. I think it's self-explanatory and might be covered by a couple of my cohorts up here. I'm also not going to talk about Rule 77. I'm going to skip to Rule 72 very briefly, which, as I said earlier, Rule 72 is not part of your materials, but there has been a proposed change, rule change on that. Rule 72 basically deals with agency appeals. So when there's a final decision at the DLIR or some other agency and it's appealed to the circuit court, Rule 72 in essence tells us that the appellant has to designate the record on appeal and take care of preparing an order for the clerk to fill out that orders the appeal from agency to transmit to circuit court the record and to certify that it's the real McCoy. So there are current forms that people use for that now. They are attached to the rules of civil procedure. There's a couple of forms for that. So the proposed rule changes in essence say we're going to do that electronically now, but if you're not a Jeff's user, and the reason for this is because so many appellants on agency appeals are self-represented litigants, there's going to still be a lot of hard copy use of the old forms. So for those of you who do agency appeals, I don't know if there are any of you listening or here today, but we have proposed rule changes to address electronic version of that as well as conventional style for the non-Jeff's users. And the electronic form will be available from circuit courts, I'm told, for you to do this electronically. So that's all I have on the rules of civil, or the proposed changes to the rules of civil procedure. I'll turn it over to Judge Castagnetti on circuit court changes.
Hi, everyone. Thank you very much for coming today, and thank you for braving the little downpours we've been having and coming out for this. You know, my approach to what I'm going to talk about, and I'm going to talk about proposed changes to the circuit court rules, but when I thought about what I was going to talk to you about, really is, if I was looking at it was if I were still a civil practitioner, what would I want to know as a practical matter about the rule changes? How do I, get a hearing date? Judge Chang will talk about that, but I'll touch on that a little bit since the circuit court rules has a rule about civil motions practice. How do I submit proposed findings of fact, conclusions of law, or proposed orders and judgments? So, one thing to keep in mind too is that for once we go to Jim's or Jeff's on October 28th for circuit court, is everything will be electronically filed, and that's everything except for maybe confidential settlement conference letters. Those should still be submitted confidentially to the court, but everything else is going to be electronically filed. So I hope what I give to you will be, answer some of the burning questions you may want to know about. The first thing I want to talk about, though, is some preliminary or housekeeping matters about the circuit court rule changes. So if you have those in front of you, I'm going to start first with Rule 1.1. And I agree with what Judge Ashford said. A lot of the rule changes are self-explanatory. So if you just go through them, you'll get the point. And with respect to Rule 1.1, it's a new rule and it's construction. It's titled Construction of Rules. And the thing you want to note here would be in 1.1a, and again, this is on page 1 of your materials for circuit court rules. It just basically covers if there's a conflict between the rules of the circuit courts or the rules of the Hawaiʻi electronic filing and service rules or the court records rules, then the Hawaiʻi electronic filing and service rules govern. And this is a rule that is also in the rules of appellate procedure. There's a comparable rule and also one in the rules of penal procedure, so we felt that we should have this rule change as well in the circuit court rules. Also, the rule notes that if there's a conflict between the circuit court rules and the Hawaiʻi rules of civil procedure or the Hawaiʻi rules of penal procedure in civil cases, then the rules of civil procedure would govern. The other housekeeping item that I want to bring to your attention would be Rule 2, subsection I, which is on page 3 of your materials for the circuit court rules, which subsection I says electronic filing of documents submitted on paper, filing date and time preserved. This rule is important in two respects. One, if you're involved in a case where there's a pro se party and they're not a Jeff's user, so they're conventionally filing their documents. The process is they'll go to legal documents and they'll conventionally file their document, and then the legal documents clerk will then upload it and into the JIM system. So the filing date that governs would not be the electronic filing date that you would see. It would be the actual filing date of when it was conventionally filed. So that's the point of Rule 2, subsection I. But also, and I think Judge Chang, you're probably going to touch on this a little bit more, but the week before we go into electronic filing, so that would be the week of October 21st through the 25th, there's going to be a blackout period for Hawaiʻi. You folks can still file documents the conventional way, going to legal documents and filing them, but they won't be docketed in our old system. They will be uploaded after we go live into electronic filing. So if you have deadlines the week before we go live for electronic filing, conventionally file your document, and the date that governs would be the one that shows it was when it was conventionally filed, as opposed to when it was electronically filed in GIMS. So those are just the two really preliminary housekeeping matters I have. The next area I want to talk about are motions, hearing motions, non-hearing motions, and ex parte motions. So if you could turn to page 7 of your materials, which is it's rule 7.2, which is civil motions practice. Subsection D is the rule that talks about form of motions. So the form of the motion being, we have the requirement of Rule 3, but every motion has to indicate, of course, the title of the motion, the name of the judge, the hearing date and time, and whether it's hearing or non-hearing. So this is it's what you're doing now, which is on the first page of your motion, opposition or reply, where you put on the side underneath the title whether it's a non-hearing motion or motion, hearing date and time, etc. So that doesn't change. Hearing and non-hearing motions must still have a notice of hearing or notice of motion. So when you file your motion, whether it's a hearing or a non-hearing motion, you still need to have a notice of hearing or notice of motion. And that's in Rule 7.2, subsection D, subsection 2. So about a little less than halfway down the page. That rule hasn't changed also. Ex parte motions, for ex parte motions, instead of lodging them, you're going to file your ex parte motions. So no longer lodging them and submitting to the court in advance. You just go ahead and electronically file your ex parte motions. You still need to have a proposed order attached to your ex parte motion. So that's in Rule 7.2, subsection F, subsection 3, which is towards the bottom of page 7. So I wanted to point that out because I think it's important for everybody to know the form of your motion stays the same. I also want to draw your attention to Rule 3D, which is on page 5 of your materials. And that says, let me get to it. At the bottom of subsection D, for electronically filed documents, the document shall be filed as separate documents pursuant to Rule 2 of the Hawaiʻi Electronic Filing and Service Rules. So I bring this portion to your attention because it does reference the Electronic Filing and Service Rules, Rule 2, and specifically, you might want to note this down. Rule 2.3 of the Electronic Filing and Service Rule says that each supporting exhibit shall be scanned or created as a PDF document. The size cannot exceed 10 megabytes. And this is really important in Rule 2.3. Exhibits to be submitted are to be submitted as separate JEFs attachments to the lead document. So if you have a motion or an opposition or a reply that has exhibits attached, according to Rule 2.3 of the Electronic Filing and Service Rules, those exhibits would be separate JEFs attachments, and you would attach them to the lead document. Hopefully you folks have gone to the JEFs training and you know what I'm talking about. If you don't, well, you'll figure it out after October 28th. But everything else is part of your motion, opposition, or reply. So like a declaration, your memorandum in support of your motion, your any other affidavit, certificate of service, all of those can be filed as one document, and then the exhibits would be the attachments scanned separately. Okay, so I wanted to point that out, that that's the process and the form of the motions once we go to electronic filing. With respect to hearing dates and how you're going to get assigned a hearing date by the judge, and Judge Chang, you're covering this, right?
Yes.
Okay, so I don't want to dwell on it too much, but if you go now to Rule 7.2 G1, which is on page 8 of the materials. Again, this is still the circuit court rules, and this hopefully looks familiar to everyone. This is the rule that governs hearing motions, and it's divided between when cases are assigned to a judge, those that are not assigned to a judge, and also for the other circuits, 2nd, 3rd, and 5th Circuit. So generally, what I just want to point out is that in the 1st Circuit, cases assigned to a judge, the rule, and I'm looking at 1A little I love the circuit court rules, tracking this. It essentially stays the same. The process is that the judge will assign a hearing date, and then once you get the hearing date, then you'll go ahead and file the motion with the hearing date plugged in. So the question is, how do you get a hearing date from a judge in the 1st Circuit? Well, when this would exclude foreclosure cases on my calendar, but for everybody else, you'll email your unfiled motion to the judge's division, and then the clerks will look at it, calendar it, assign it a hearing date, and then notify you of the hearing date and time. You plug that information into your notice of motion or notice of hearing and on the front page of your motion, and then go ahead and electronically file the document. It's really the only difference from the procedure now to what it will be once we go live is, currently what you do to get a hearing date is you drop off your unfiled copy of the motion, or your messengers drop off the unfiled copy of the motion to chambers, and then the clerks fill in a hearing date, and then it's returned to you folks for filing. The only difference is now you request it by email as opposed to dropping it off in chambers. For foreclosure cases, how you get a hearing date in the 1st Circuit on my calendar will be you'll email a request for a hearing date to the legal documents branch, and then they will go ahead and assign you a hearing date. Now, I'm sure you're wondering, how are we going to know which email to send it to? We're going to have a Jeff's Guide that will be on the judiciary's website that will have information about this, and will have all the divisions, all the judges' emails, where you can request your hearing dates from, as well as legal documents. Okay, so hopefully that answers your questions about how to get a hearing date. Yes, Ken.
So when we email the unfiled motion to chambers, do we also include all the exhibits or just the motion?
Just the motion. So, and yeah, oh, sorry, I have to repeat the question for those who are watching online. So the question is, when you email in the 1st Circuit, when you email the assigned judge's division to get the hearing date, whether you need the motion and all the exhibits or just the motion itself. So the answer would be just the motion itself, and probably the memorandum in support of the motion, because that will give us a sense for scheduling purposes how long we expect the hearing to take, but also how much preparation time it would take for us as well. Okay? And I don't want to dwell too much on it, because I don't want to steal Judge Chang's thunder on this. But the real question too is, you need to make sure don't file your hearing motions before you get a hearing date, because if you file it, nothing's going to happen without a hearing date. We'll ignore it. So that won't happen. But anyway, so that covers that. I think for the 2nd, 3rd, and 5th Circuits, to obtain a hearing date, their process would be you contact the assigned judge's chambers for a hearing date, and you will get assigned a hearing date by telephone. Ex parte motions, again, looking at Rule 7.2 G3, just make sure that your ex parte motions that are electronically filed, again, they don't get lodged, you just file them electronically, that they are accompanied by a proposed order. Now, this is one of my favorite parts of the new rule changes. If you go to page 10, and we're still in 7.2 G6, but on page 10 of your materials, 7.2 G6, copies for judge. Now, I know a lot of people think, great, we're going to electronic filing. The judges don't need copies of any of the briefing. No, we need our copies. And the reason for this is, we think of it from our perspective. We have a lot of motions that come on calendar. For most of the judges, we want hard copies of all the briefing because we take active notes. We write questions. That's how we prepare. And we need the exhibits. We need the exhibits tabbed on our copies. For my calendar alone, I have anywhere from 15 to 25 motions for summary judgment a week. That's not the other days and the other types of motions that I hear. And usually those motions will have anywhere from 5 to 10 exhibits. And you don't know what it's like to have to, or maybe you do because your copies don't get tabs. But for us to go through and when we're looking at exhibits to not have them tabbed, it just adds time. And I will also note that the rule regarding courtesy copies for judges, that we need 2 courtesy copies, it shouldn't come as a surprise for those who practice in federal court because the local rules in federal court also have the same requirement. So please make sure to drop off your 2 copies with tabbed exhibits to the judges, and we will be much appreciated. All right, so a couple of other practical highlights that I want to touch on with you folks on pertains to submissions of proposed orders, judgments, and decrees. So that would be Rule 23, and that is on page 12 of your materials. And I know Judge Ashford already mentioned it, but the process for Rule 23 will be the same. Okay, under the circuit court rules, the prevailing party prepares the order or the judgment, and then they try to get approval as to form from all the other parties. You do that first. Don't just go ahead and submit a notice of proposed judgment. The rule does require that you need to try to get approval as to form from all other parties. Rule 23B is still the same. If you don't get approval as to form after you make a request in writing within so many days, then you can go ahead and submit the proposed order or judgment to the court for signature. Rather than lodge it and have it delivered to judges' chambers, you would electronically file the proposed order or judgment. And make sure it's proposed, as Judge Ashford said, Rule 9.1 of the Hawaiʻi Electronic Filing and Service Rules does require that your proposed order and judgment be clearly marked as proposed. Once it comes into our chambers for signature, we'll review it. We'll be able to modify the order, but also take out the proposed and then insert our signature on the order and so forth. So that's the only difference with Rule 23. Yes?
Okay, so I'm confused about that. We're sending it in a PDF, and the order is going to say proposed order.
Yep.
So you guys are going to convert it back into Word, take out the word proposed?
We'll either convert it or we have the program that allows us to edit in Adobe. Right.
So I'm going to jump in and I'll also remind you to repeat the questions.
Oh, thank
But
you.
I think I heard from somebody, in case anybody here was smarter than I, which includes the whole room, can opine, but I think that the word proposed is supposed to be on the cover page or the fly sheet so that we can, in practical effect, just disregard that first page other than knowing it's proposed, and then all the text is going to be on the beginning on the second page. Does that sound vaguely familiar or totally wrong?
I'm not sure.
Okay.
I don't even know what a fly sheet is.
Like a cover page?
I mean, we usually submit a letter.
Right.
Right.
Is that the fly sheet?
No.
So I've never known what a fly sheet is.
You ever record anything at
It's a
the
great
Bureau of
question.
Conveyances?
This question is what a fly sheet is. It would be the cover, the pleading with the caption and your name and identification, and in the document inventory section, it will say proposed order granting motion for summary judgment or whatever it is. That would be the first document you attached. Under that document will be your proposed order.
Which is going to have the caption repeated. So basically, we're having 2 caption pages.
Yes.
Huh.
But the second page would not say proposed order, it would say order.
There's going to be some confusion about that. So whether or not it says it is the order that we select, we can modify it so that it will just say order.
Yes, Brandy.
Just a quick question. Sometimes the circumstances for us submitting a proposed order require a little bit of background. Usually, previously, we would submit a cover letter, copy to opposing counsel, letting them know if there are some particular circumstances concerning why we couldn't get consensus. Now, when we submit that, if we need to provide those circumstances, do we include it with the email attaching, copying to opposing counsel?
The question is, when counsel submits a proposed order, sometimes there's some discussion in the cover letter explaining what the dispute is and why their form is preferable. There is a practice that I've seen where lawyers will file a document called notice of submission, and then they'll have the name of the order, proposed order granting summary judgment. I think that is a good way to carry out this procedure for filing proposed orders, is to submit a notice of submission of proposed order with the title of the order. And in the text of the notice of submission, you can set forth all of your argument that you normally would have included in your cover letter. And then your second document behind the notice of submission would be your proposed order.
Thank you.
Yeah.
Thank you, Judge Chang. Any other questions? Larry?
Yeah, you had said that in the First Circuit Court, if you're filing a foreclosure document, you file it with legal docs, right?
Yes, yes.
Does that apply to the Outer Islands as well?
Okay, well, no. For First Circuit, you would make the request for the hearing date to legal documents, and then legal documents will assign a hearing date, and then you would go ahead and electronically file your motion. That would be the process. And then in the neighbor islands, look at it like you just would contact the assigned judges, chambers, and request the hearing date.
Like any other?
Because there's assigned, the foreclosure cases are assigned to any of the other circuit judges, so you would treat it like anything else. Okay, you're welcome. Mitzi?
I understand that when we file, like, for example, a motion for summary judgment, the exhibits get filed separately. When we submit our two copies to the judge, are we submitting the exhibits separately, or do you want to all put together like we do in the class?
Okay, so the question is, when the courtesy copies to the judge are submitted, whether or not the exhibit should be separate from the motion and the rest of the supporting documents. No, you can just submit it in one complete document. Okay.
Tabbed.
Thank you. Yes.
Going all the way back to a very basic question, but when we started, it was told to us that under Rule 1.1, registration is required. And I'm just wondering, did I miss something previously? How do we register?
Okay, so
the question is, how do you register for Jeff's?
Yeah, for Jeff's and Jim.
I have an answer to that, which will be in our Jeff's guide, but it's really, you go to the judiciary's website. Oh, God.
Google it.
Google it. Thank you. And from there, I think you click on e-filing.
I'm sorry to bother you.
That's all right. It'll be on if you click on e-filing, I see Judge Ashford looking at his watch for me. I think, are you cutting me off?
No, I'm getting text from my staff
Okay.
who are watching.
You would go to the judiciary's website, you click on e-filing, and then click on Judiciary Electronic Filing and Service System, Jeff's login page, and from there you'll be directed to where you need to register for access, and then you fill it out. Okay? You're welcome. Yeah.
When you commence a case, you file it. Right. Right now, what you got to do is basically attach a blank summons. The clerk stamps it, certifies it, and that's what you serve. Under the new system, what do you serve?
The question is, what do you do about a summons in e-filing? Online, they will have pre-signed summonses that you can download and fill out and then attach to your pleadings.
Thank you. don't have too much left for my presentation. The next rule I wanted to bring to your attention is Rule 21, which is on page 11 of the proposed circuit court rules. And again, this pertains to submission of proposed findings of fact and conclusions of law and a jury waive trial. And again, just bringing to your attention, which we've already covered, is the fact that you would need to submit them as proposed findings and conclusions. The last two items I have, just real quick: service and filing of discovery documents and filing depositions. For a lot of practitioners, when you take a deposition and those depositions then get filed with legal documents, you no longer need to file your depositions. Rule 16 on page 10 of your materials covers now with depositions, the original deposition. And basically, you just need to know that, and this is similar to the local rule, it's just the attorney who's responsible for the preservation of the deposition to produce the original transcript if it's needed for court proceedings or when filing or using in court proceedings or ordered by the court. So you don't need to file the original deposition transcript in court or submit it before trial. You would just follow Rule 16, and that would be the process you file depositions. Okay? So that's it. That's all I have.
Okay, I'm going to talk about GIMS a little bit. And I wanted to clarify what GIMS and JEFs means. GIMS is J-I-M-S. It's an acronym for Judiciary Information Management System. And that is the big program that we're installing that permits e-filing. So within this large program, we have judiciary management of the cases, we send notices out, and judiciary staff uses one aspect of GIMS. But the other one that interests all of you is the JEFs component. JEFs, as Judge Ashford said, stands for Judiciary Electronic Filing System. That's what the lawyers do. You electronically file documents. So one component of GIMS, the big system, is the JEFs component, and that's what will allow you to e-file documents. So please don't get confused between GIMS and JEFs. Please understand that GIMS is the overall computer program where judiciary staff and lawyers can use, but JEFs is the component that allows lawyers to e-file documents and all of that. Judge Castagnetti mentioned that there is going to be a blackout period 1 week before the go-live dates. And the 3 go-live dates are October 7 for district civil cases, October 7. Then the second one will be October 28 for circuit court civil cases, October 28. And the third will be November 18, and that is for land and tax appeal cases. Land court and tax appeal cases, November 18. So 1 week before those go-live dates, they are going to seal off the Ho'ohiki information. So if you used Ho'ohiki in the past, you will not have new updated information for documents and information that would have been entered into Ho'ohiki for the week before. And the reason for that is we're going to take all of the existing cases over the weekend before the go-live date, and we're going to electronically migrate those cases, the electronic data, migrate those cases into the GIMS so that all of the electronic data, documents filed, when they were filed, case names, the parties, all of that will now be in the GIMS or JEFs system. What will not be in GIMS or JEFs are the documents themselves. The documents themselves will not be accessible online through the JEFs or GIMS program. Those are too much information to migrate over, and we could not do that in the weekend before. So please understand that documents that were filed before the go-live dates will be manually available if you need the file at the courthouse, wherever you practice. Okay, so please remember that. But the electronic information that was searchable in Ho'ohiki, that information will come over. But the week before, no new information will be inputted into Ho'ohiki. The rules that you need to be aware of with this new JEFs filing system are the Hawaii Rules of Civil Procedure, and if you do district court practice, then the district court rules of civil procedure. Secondly, you will also need to know the rules of the circuit courts of the state of Hawaii. There are changes to all of those rules. Third, the Hawaii electronic filing and service rules. That's very critical that you read those rules. They're not as long as the civil procedure rules, but they are chock full of requirements for e-filing. And fourth, the Hawaii Court Records Rule. I want to point out Rule 9 in particular. That's a particularly problematic rule. It is the rule that relates to personal information, and personal information is not all confidential information. Personal information is identified as certain categories of personal or sensitive information that need to be treated separately. And there's a complex procedure that you need to follow. And there is a case with the defendant's name is Takase, that's Judge Barbara Takase from the Third Circuit. And it lays out a lot of detail on how to implement Rule 9. So I'm just pointing that out because that is going to be very critical for your practice anytime you are filing personal information. And that includes Social Security numbers on financial records, account numbers, birth dates, all of those things that are used for identity theft are now personal information that requires special treatment. The judiciary does not want that information in the records so that people can steal identities. If you forget and the court should come across information, then you'll be notified that you need to correct that situation and go through all of those steps required. So please read Rule 9 of the Hawaii Court Records Rule. It was mentioned several times, but JEFS is now mandatory for all lawyers. Lawyers will not be permitted to conventionally file over the counter. Mandatory e-filing for all lawyers using JEFS. And when you file a document, the format of that document must be in a PDF format. PDF is portable document format. If you try to file it in a non-PDF format, you'll get a pop-up that will reject your document and not permit you to file it. The reason for that is we need to maintain the integrity of documents that are filed, so we cannot have people going into the JIM system or the JEF system and then modifying documents. So we require all documents to be in a non-modifiable PDF format. So all of your computer systems need to have the capability of making sure that the document you create can be transformed into a PDF format so that you can e-file it. Judge Castagnetti mentioned that your lead document, which are all the non-exhibit documents, should be e-filed together. And the Hawaii Electronic Filing Rules, this is why you need to read them, requires that all exhibits be separately filed from a lead document. And each one of those documents, whether it's a lead document or exhibit, all of them cannot exceed 10 megabytes. Now, people are wondering, how big is 10 megabytes? It is an electronic measurement that we cannot predict. It is not equivalent to a number of pages at a certain font size. It depends on the computer program and how the resolution on your computer program is. That dictates how the megabytes will be counted. And if you have a photograph or a diagram, that eats up a ton of megabyte space. So a photograph included in the materials will eat up a lot of space. If your document exceeds 10 megabytes, a pop-up will come up and you'll be notified that your document cannot be filed in its current form and you've got to break it down. There's a question?
I'm not clear technologically what you mean when you say separately submit. The exhibits are separate. My understanding is you have the lead document, and in that same, I don't know what you call it, submission, you can attach the exhibits. Or are you saying you submit the motion and memo, and then you separately file a separate thing with the exhibits? I'm not clear.
Okay, thank you. The question is, can we clarify what we mean by documents must be separately filed? to meet this requirement in the electronic filing rules. When we say separately filed, we're talking about each time you use one application to e-file a document, a single document that you're e-filing all at once is one document. And your lead document for a motion includes everything except the exhibits. So your motion, your memorandum in support, declarations, and all of that, affidavits, can all be one document that you e-file all at one time. Then, the next document you e-file, which means you have to open up a separate page or sheet or form to e-file that you have to fill out information so you can e-file a document. This will be a separate page that you open a new form so that you can e-file a separate document from the lead document, and each exhibit must be separately e-filed. You cannot e-file them in a group any longer. All lead documents, which includes everything in the motion except the exhibits, and exhibits must be separately e-filed. And each exhibit must be separately e-filed. You cannot file multiple exhibits together. If your lead document, which is your motion, memorandum in support, declarations, affidavits, if that exceeds 10 megabytes, you're going to have to break that down into two separate documents that you e-file each part separately to meet the 10 megabyte limitation. Did that answer the question?
Yeah.
Okay. All right. Any other questions so far? Okay. Service of documents. Now, all lawyers will, as soon as a document is filed, all lawyers and the assigned judge will all receive an email called a Notice of Electronic Filing. They call that the NEF. You will receive by email an NEF that will have all of the information and the title of the document, but it will not have the document. So please understand that the whole JIMS system and your personal email are two different computer systems. So we have not created the ability when you receive a NEF to click on that document and then the document will appear. We don't have that link. So you are going to have to look at your NEF, identify the document that you are looking for, and then on a second computer, and that's why some people say it's good to have two screens in your office. Then you go into the JIMS or Jeff system and you search your case for that document. You click and there'll be a PDF icon on the extreme right of your sheet that shows indexing all the documents. You click on the PDF that corresponds to the document. That will open up the document. So please understand there is no link from the NEF, the Notice of Electronic Filing, that you'll receive by email, and the actual document. So a lot of the computer functions depends on the information you provide when you register and get your Jeff's number. So if you give the wrong email address, or if you change your email address and you don't let the Jeff system know, the NEF will go to your old email or the improper email that you put down. So make sure that you update the email information, because that's how documents will be served on you by reason of the court rules. Okay, so please make sure that email is current. What about service upon self-represented parties? Old-fashioned way. You must mail them a copy and then include a certificate of service and probably file a certificate of service showing that you've mailed it. So your certificate of service might say that certain parties have been electronically served, and certain parties have been conventionally served by mail. So make sure that you adjust your certificates of service as well.
Judge?
Yes.
When we have whether we have Pro Hac Vice counsel in there, frequently certificates of service will say we mailed them to this guy, so we e-filed them. Going forward, will we just e-file on the certificate of service, just make a note that we're e-filing it to the local counsel, and not make any representations with respect to the mainland council?
You can if you want, but service upon local council will constitute service upon all pro hac vice council as a matter of law. So you can put that in the certificate of service if you want, but it's not required. Yeah. Okay. And we apologize for the lack of that link. There's been a lot of requests for that, but there are some policy questions because you can forward that email to anyone in the world, and then anyone in the world can get access to the document, and that could be problematic, particularly if the document is sensitive. Question in the back?
So right now, when you file something on devs, like let's say a motion with the certificate of service in the back, typically in our certificate of service, we'll say we certify, we serve by mail or by post office the following persons. And so now we will say, we will include service by electronic just filing. For the conventional people, parties, what happens is once we file that motion in JES, we get an email back from JES with the notice of electronic filing, and it'll say at the bottom half, you need to conventionally serve the following people. So do we now have to file another certificate of service to say that we conventionally serve? Because we got that NEF that says we got a conventional service. So do we have to do a follow-up certificate of service, or is the original certificate of service that we filed with the motion is sufficient?
The question is whether a second certificate of service must be filed in addition to the one that's already attached to the motion, reflecting the conventional service upon the self-represented parties. And this is a situation, everything is going to happen really quickly. Within 30 minutes of you filing a document, that document will be in the record, and almost immediately, even before the 30-minute time, you'll get an NEF. The NEF will state who's electronically served and who should be conventionally served, because every party who is not a lawyer or a judge is going to have to be conventionally served. So the system will identify that. So you can, the day that you e-file your document, you can mail something to the self-represented parties, because within 30 minutes, you'll have a copy. And you can deposit it into the mail anytime that day. So your certificate of service should be the same date that you attach to your original certificate of service that you e-file with your document. You should do everything the same day, but if you have an office that is not very organized, then you're gonna have problems. And if you serve on another day, then you better have a correct certificate of service, because we judges rely on that when there's issues about, Judge, I didn't get it. We look at the certificates of service to see the dates and how it was served. So it could be problematic. So if your office is not efficient to get things served on conventionally served parties that day, you might have to do a supplemental. Okay?
Can I add something
Sure.
too? So, Rule 5D of the Rules of Civil Procedure says that except as provided in subdivision F, this rule, all papers after the complaint required to be served upon a party, together with the certificate of service, shall be filed with the court either before service or within a reasonable time after service. All documents conventionally filed with the court shall be previously or contemporaneously served on all parties to the action. So as Judge Chang was saying, as long as you do it that day and it's contemporaneously or it's within a certain period of time, then I would say no, you don't need a separate certificate of service. But if there's any lag time, you should do another certificate of service.
Okay, question?
Your Honor, on JEFs right now, in terms of on the appellate court level, you're only able to access your cases. Is that going to be the same for JEFs when we transition over?
You can only access your case through JEFs, but you have, instead of ho'ohiki, you will have something called e-court kokua that you can look at, and that's what the public can look at any case. But access to documents will be limited to your case. Yeah. Question?
You said that staff couldn't become registered JEFs users. So will any staff that are registered also receive the NEF emails?
I believe so, yes. The question is the staff members who are given JEF's privileges, and it's not all staff members. It'll only be maybe one staff member per firm, very limited. But that staff member, when they register, will have to put an email address, and on the cases that they file a document or are involved, they will get the NEF as well. Yes.
Question about hearing motions. Judge Ashford had mentioned that you first email the motion to the judge's chambers to get a hearing date. Once you get the hearing date, you go back and file in Jets. So will the filing date be the date that you submitted the email to the judge's chambers?
No. It is when you e-file the document. The question is, if you submit a motion and you email it to the chambers to get a hearing date, is that the e-filing date? No. It is still when you e-file the document that will be considered the e-filing date. Because everything is generally so quick. And 4:30 doesn't mark the end. So we can email you the hearing date. You have until midnight to e-file your document. So you might have to work a little bit beyond midnight. 4:30.
Well, no. Judge Chang, when I'm submitting my motion to you for a hearing date, am I copying all the counsel on that email also, since it's a communication with the court, so they know I've submitted a motion for a hearing date?
I don't think that's necessary. I think you can just, like, when you deliver a motion to our court now, you don't tell everybody you're delivering, you just deliver the motion and we assign the court date and you get it back. So no need to email all counsel when you email the court and asking for a hearing date. Question?
I have two questions about original or certified copies that are being filed. I see the rule relating to wills. And it says that when we file an original will, it has to be accompanied by a pleading stating the reason that the will is being presented to the court. So I'm assuming that would be the application or petition that would normally come when we're opening a probate. If that's not a separate kind of pleading. And the second thing is that the same procedure if we're filing a certified copy, for example, a certified copy of a death certificate? So I understand that if we're filing the death certificate electronically, it would be filed sealed electronically. But we then would have to present the actual certified copy to the court, correct?
Jim, you can answer that one.
I think to Judge Castagnetti.
Okay, the question dealt with filing original documents such as a will and filing of certified documents such as a death certificate. My understanding is that probate court has a statute that requires that the original will be filed. The electronic filing rules, again, this is why it's important to read it. The electronic filing rules permits an original document to be held in the attorney's possession and that a copy be filed. I think that is the procedure that a probate court is going to permit now that we have e-filing. So please read the electronic filing rules and understand for original documents such as a will or a certified copy, counsel of record can hold that in their office, but they need to take care of that document. You can e-file a copy. I believe that's how it's going to be handled.
I think I'm not familiar with this. I don't claim familiarity. I'm just trying to read quickly. Were you referring earlier to Rule 2G of the Circuit Court rules?
I was referring to Rule, yes.
Okay, because I think that covers it, but I haven't studied on that, to be honest, so I'm just suggesting you refer to that.
Right, so my first question was with respect to Rule G. It does seem to say that we must present the will to the clerk, and it says that the will has to be accompanied by a pleading stating the reason that the will is being presented. So I was just double checking that pleading is not a separate kind of pleading, it's the normal application or petition that we would present when we're filing to open a probate. And then the second one was my double checking that we would follow something similar if we were doing something like presenting a death certificate. So I believe Judge Chang was indicating that maybe the death certificate we would hold the original copy. But I think that Rule G seems to indicate that we still have to present the original will.
Sure, looks like it to me too.
Okay, thank you.
I know you mentioned something about the summons, downloading it online and having it pre-printed already. Is the same applies to the subpoena?
Subpoenas as well, both subpoenas and summonses. The question is that the we indicated that the summons will be available on a fillable form and to download and pre-signed. The question is, what about subpoenas? Same rule for subpoenas. You can download a fillable form of the subpoena that will be pre-signed as well. I believe they will be pre-signed by a court official, not the judge though. Okay, now I note that we're past 1 o'clock and we're willing to stay, but I think we have to officially end it, and we have a little bit of information for anyone who wishes to remain in the room or stay online, but I think we're running a little over time and we just love the questions, so we're going to continue to entertain the questions. There was a hand here, so thank you for those of you who have to leave. We are sorry we're going so late.
Judge, for subpoenas, has any consideration been given to following the federal procedure where the attorneys just sign the subpoena and serve it?
Well, there was discussion about that, and the decision was to have them pre-signed by the court official. And so it's available on a fillable form online. Kimo?
I have a lot of questions. I'll just ask one now. So the civil information sheet, you know, our training, it looks like including all the information that's currently in the civil information sheet electronically. Then we have to also fill in the civil information sheet?
Also required still.
What's the, that just is insane. Like, what's the point of that?
There's a lot of insanity that exists. Yeah. Question in the back?
The summons, the pre-signed summons, where that's found?
I don't know where it's going to be found, quite frankly, but it's supposed to be available on the Jeff's website. So somewhere on the Jeff's website. I'm sorry, I don't know the exact thing to click on. Yeah.
You mentioned that the PDF has to be non-modifiable. Does that mean we have to scan it in and can't just use the converted version? Because I think people who get the converted version can convert it back to Word. That's why
Well, we don't want the people to fiddle with documents that are e-filed with the court system. So what goes out to other people, we don't care. But what we're concerned about the integrity of the e-filed documents with the court. So that's all that is required. If you want to send non-PDF to everyone else, that's fine. But it has to be PDF or the system will reject it for e-filing documents.
I think the question was different. There are different types of PDF files. A PDF can be a straight image which is scanned. That is totally inaccessible to somebody that uses a text-to-readers program and doesn't satisfy the requirements of the Americans with Disabilities Act. In Florida, where I'm also licensed to practice, we have to submit, and in federal courts, we have to submit documents in a PDF/A-1B, which anybody that modifies it, it automatically changes it. They cannot modify the original document. And I asked a question about that to Jeff's person several times, and it took several months to get an answer, and they say, well, that's not part of our rules. So the question that I wasn't going to ask until afterwards, rather than get into the technical stuff, is how are you going to provide the accessibility to people that are disabled, and how are you going to ensure that some of these documents that are filed scanned, which have to be converted into a document that can be read and edited, because the professional version of Adobe will allow you to edit the document, but you have to go and convert it, and then the conversion has some problem. And so there are different ways to create it, and the rules are totally silent on this.
Okay, the question is, there are different forms of PDF documents, and what is going to be required for the judiciary e-filing system on Jeff's. The ADA form of PDF is not going to be required, so everyone is not required to file on every case a ADA PDF document. But if someone on the document requires a reasonable accommodation in the form of a special PDF document, then I think you have to contact the judiciary office that deals with ADA accommodations, and then they will arrange for that requirement to be available for people on that particular case. But it's not a general requirement for all cases.
What you said is kind of the answer I got from the OEAC, I think. The problem is that every time I've contacted them, I've actually had to talk to the Chief Justice to get an answer from them. And so people are supposed to have the same access with disabilities that everybody else does. So on your e-court Kokua, how are you going to do that?
It's not going to be available on e-court Kukua. No. Only the parties to a case involving a party who requires that special accommodation will be required to file in that special PDF form.
We can talk about this later. I don't want to take up that much time, but
Okay.
there's a lot of technical information that I personally have.
Okay. Kimo.
Okay, let's talk about submitting orders. I don't feel comfortable putting another attorney's S under their signature. So can I just, in my what we call it, the notice of submission of an order, I just say, the other attorneys all agreed, they're all getting a copy of it at any rate. Here you go, and I'm not gonna have any other signature lines except for the judge's signature line. Is that fine?
You should not put another lawyer's /S/signature or name on a document unless you have the written authority to do that. So it's never a good idea to put someone else's e-signature on any document. If you submit a document, the question is, what do I do about filing a notice of submission with a proposed order and the other signatures? My suggestion is that if you use the notice of submission technique, instead of circulating the document in the traditional form that everyone else has been using, Rule 23 to approve documents, then you would submit a document that is unapproved by all other parties and counsel. Unless you have a document that is partially approved, then that's what you would e-file, the partially approved document. And since you don't have everyone's, then you're giving everyone in the case notice that you're sending a document as a proposed order. E-file.
If everyone's agreed though, I mean, the signature thing seems, we can't really do signatures.
Well, I mean, Judge Castagnetti might be able to address that, but my understanding is that there was an idea to propose that, and it's not in the proposed rules.
Would you be able to submit the proposed rule with your signature on it and just notice the other guys that your signature is required?
I've seen lawyers do that, and I don't see anything prohibiting that. So I notice some lawyers don't want to get everyone's signature, and they'll just send a notice of submission in. Question.
Yeah, I just wanted to mention that in the federal court, and I don't know, I haven't read the rules carefully enough to know whether this applies here, but in the federal court, what you do is you get everyone's signature, and then you electronically file a copy of it, and the lawyer who files it has to maintain the original of all those signatures. In the same way that for a declaration, you have to maintain the original of this.
The question is, well, in federal court, a lawyer will get signatures from everyone or authorization, and then just keep that, but submit a clean document for the court to sign. In the industry, I understand that is called an attestation, where the attorney will either physically or by email get the other party's permission to make a representation to the court that everyone has approved the order of this form of this order, and then they have to keep in their records all of the documentation that other attorneys and parties have approved in the event of a controversy. There was a suggestion as to maybe that should be adopted, but the proposed rule did not adopt the attestation procedure, so we don't have that available in state court. Yes?
So it sounds like you're saying you don't have to circulate for approval a proposed form of order. You just file your notice of submission.
We're not saying that, but I'm saying the practice has become that some lawyers do that.
On the Big Island, that's very common.
Yeah, and so I'm not saying that because Rule 23 still requires that you prepare the prevailing party prepare the order, and that you have to try to get everyone's approval.
So
I'm sorry, the question is, it sounds like the notice of submission procedure does not require people to comply or obtain actual approval as to form of the order. So my answer is, the Rule 23 still says what it says, and it still requires that everyone try to get the approval as form. But the practice has evolved where some people just submit a notice of submission, and some or all of the parties have not approved the form. And no one has objected to it. It has not gone to the Supreme Court. So that's how the practice has evolved in the last 40 years that I've been practicing.
So if you do obtain signatures, couldn't they be in the form of a wet signature? You then copy it, scan it, PDF it, and then you file it.
The question is, if you get wet signature, ink signed documents, can you just upload it, scan it, and then e-file that? That's exactly what you do. You scan it into the system and e-file that document as a PDF document.
Discovery, the rules don't appear to have been amended to specifically authorize service of production of documents, interrogatories, admissions through email. Am I right? Or do they actually allow us to do that?
You know anything about that?
Not aware of any changes.
The question is, can parties serve discovery requests by email? I don't think that the rules have been modified on discovery, so I am not aware of that. If there's an agreement, then you certainly can do that. So it might behoove you to contact opposing counsel or the parties to see if that's acceptable, because it certainly would save on paper costs. So
I think the rules currently right now for service of discovery requests or service of any documents other than the initial complaint would be that, you can't have service by email. There's nothing in the rule that allows it, right? We have our electronic filing and service rules. So to answer your question, Kimo, about can you serve discovery requests by email, the answer is no. I don't think there's anything preventing the parties from agreeing to service by email if everybody consents to do it that way. I will share with you that the Civil Rules Committee, we did have a discussion about whether or not Rule 5 of the Rules of Civil Procedure should be amended to allow service by email as an option. But the discussion was, though there might be firewalls that would prevent somebody from getting the email, there could also be an issue with respect to whether proving service that it was actually received. So the ultimate decision was made not to allow service by email. That is an issue that's part of the Civil Justice Improvements Task Force report, where the task force had recommended service by email and amending Rule 5. So that's still up for debate. It may change eventually.
And following up on that, Judge, I understand that the comments, and I've reviewed the new rules proposal, and they're quite extensive, and to a certain extent similar to federal court procedure. I'm wondering, I know that the deadline for submission of comments to that is December of this year. Do you have any idea when and if those rules are going to be implemented in the future in whatever format they might take?
I don't know the timing of that, but thank you. So the question was about whether or not the timing of when for the proposed recommendations and rule changes by the Civil Justice Improvements Task Force, when those would take effect. So I can't answer when it would be actually implemented and what changes and so forth. But I would encourage everyone to please take the time to look at the task force report and the recommendations and the proposed rule changes and comment by the deadline, which is December 2nd. And again, that's all available on the judiciary website. I think under the heading proposed rule changes, you can find the report there.
Yes, thank you.
Question?
I know that on the system now you can just check a box and file a document under seal. If you have a protective order in place in your case, are you able to just go ahead and file it under seal, or do you still need to go through the process of an ex parte motion to get permission?
Did they do it the rule on seal? Well, the rules on sealing a document have not changed. So I think that the procedure has been that you obtain, I'm sorry, the question is the procedure, does the procedure for filing a sealed or in-camera document still the same, requiring a prior court order? I do not know of any change to the procedure requiring a prior court order to seal of record. So you can take your chances and test the waters, but I don't think anything has changed, except now lawyers can mark a document as sealed or in camera, and it will enjoy that protection. But let me just say that sealed in the Jeff system does not mean the same as sealed in our current manual system. So please be careful about that. Under Jeff's, when we go live, sealed means everybody in the case can still see the document. The public only cannot see a sealed document. So please be aware of that. If you want no one to see it except the judge, then the proper designation is in camera. That's the designation to keep it away from everyone's eyes. I don't want to confuse it, but there is a third category that was created just for civil. It's called restricted access. And the judge can limit the access to only certain parties in the case. That's restricted access, but only the court can do that. And once a restricted access or a limited access is clicked, sealed, or in camera, no one can undo that except court personnel. So be careful with that button. Once you click it, it's unchangeable. Question?
The notice of electronic filing will not have a link to the actual filed document, correct? Okay. If we're a party to the case, or if somebody who also is a party who has filed something, we receive the NEF. We will go into Jeff's to obtain the document, and that's free. Will it be a one-time look like with the federal, or is it? Will we be able to access that document again for free?
You can access it, yes, for free.
Second question, if I could. Hawaiʻi, will it just go away, or once it's frozen, will that information be there? I mean, I assume the dates will be different for district and civil.
The question is, what happens to Ho'ohiki when we go live? It's going to disappear for civil. But if you have a family law practice, because family court has not yet gone electronic filing, Ho'ohiki will be available all the way through until family court comes online with electronic filing. But civil will be offline.
But if you're not a party to the case, then you pay for the documents.
Oh yes, you have to pay for a subscription.
Yes.
And you can look at what's been filed in another case, court dates and all that through eCourt Kokua.
Will eCourt Kokua have a docket similar to Hawaiʻi?
I believe so. Yes, that will be the public access vehicle. In the back?
I have a question about the fee to certify a document. Currently, if we file documents, for example, letters testamentary, if we request 20 certified copies at the time of filing, then we just get the 20 copies for free. Will that continue on, or are we going to be charged for each of the certified copies?
The question is, what happens if you need multiple certified copies, because the current practice is that the multiple copies are free. I apologize, I'm not familiar with the probate court, but my understanding is that that will still be the procedure going forward. But you are required to pay online for certified documents or any filing fee or anything that you require. Because that stamp that is affixed when you e-file a document has a certain amount of certification behind it as well. So you should probably check with the court that you're practicing in to see how they're going to address certified documents.
Thank you.
It's not to belabor the point on the certificate of service, but I've read the Hawaii electronic filing rules versus the proposed rule on service by mail or through JEFs or GEMs. And under the electronic filing rule 3.1, it says the electronic filing of a document is deemed complete for all purposes under any of the Hawaii rules of court when a notice of electronic filing is generated, right? So in my understanding then, it's at that point when the document that you filed through JEFs has actually been served. So if appended to the document is a certificate of service that says this document has been served, at the time of submission into JEFs, that would not be accurate, right? Because the NEF is not yet issued.
Well, if you're going to, the question is, will the certificate of service that is e-filed with a document, is it going to be accurate? I would think that you're going to put the date on the certificate of service when you e-file the document.
Okay.
The problem is if you have a certificate of service and the document is circulating in your office or whatever, waiting signature, and then day or 2 or 3 pass, and then you e-file it without changing your certificate of service, there's some inconsistency there. So you need to be careful what your certificate of service says. Yes, but the effective date of service will be the NEF date.
Thank you.
Yeah.
So be careful if you're doing 1155 filings.
Right, yeah. And on that note, the comment was be careful if you're doing 1155 or late filings. I did want to go over that Jeff's is not a 24/7 e-filing service. There are certain limited times. During weekdays and weekends, please take note of this. On weekdays, Monday through Friday, you cannot e-file between midnight and 4 a.m. because the system is maintaining itself. So midnight to 4 a.m. on weekdays, you cannot e-file. Then on weekends, from Saturday midnight until Sunday 12 noon, that 12-hour period, again, maintenance is going on, so no e-filing from Saturday midnight until Sunday 12 noon. So you can e-file all other times except for those 2 periods of time. So it's not 24/7. It's virtual, but not. Any other questions? Yes.
Rule 72.
Okay.
There seemed to be a lot of, it's amended over time, and I don't know if it's completely, proposals completely addressing all the e-filing. It seems like there's a lot of missing links. So number one, any way that the rule can be amended to make it clear, particularly to new practitioners, that you don't need a summons when you file a notice of appeal. That was changed a few years ago. It used to be there's ambiguity whether you did a certificate of service or summons. Then it became clear you don't need a summons, you just need a certificate of service. But now with the new language, with e-filing, it's left unclear. And is there any way you guys can propose that rule be amended so that the notice of appeal, if you serve a certified copy, you serve a copy pursuant to Rule 5, which is how things are done after case commencement. Am I making myself clear at all?
So the question was, as I understand it, whether Rule 72 can be amended to state in black and white that a summons is not required to be served when you do a notice of appeal?
Or just refer to Rule 5 rather than so it's clear. Because for new practitioners,
right,
it's completely unclear what you're supposed to do if you have a Chapter 91 appeal.
Can I ask, did you submit your recommendation or your comments to the Supreme Court?
Not, well, whoever, I submitted it to whatever
Okay.
email link there was.
Okay, so recently, right? So you
Yeah.
made that request. Okay, so the request everything's being under review right now, and that's why we're dealing with the proposed rule changes, because the Supreme Court, I think, will be promulgating new rules. So your comment may be taken into consideration.
Okay,
So
I guess I get the sense, which I hope is wrong, that everything is done and that input is being solicited, but I'm not sure it's being really considered and to actually change what was proposed that we saw. Are they gonna, you think there's gonna propose a new draft before
I
October
don't
28th?
know. Yeah. No, I don't know.
I did want to make one last comment, and that's payment. All of you are going to be paying, so I wanted to comment about payment. Now, mandatory requirement is payment online with the charge card. And there is going to be a payment fee, administrative fee, not to the judiciary, but to the credit card company, 2.6% transactional fee for every payment that you make. So please be aware that that will be tacked on to the amount. And you have an option of paying at the time you e-file or defer that payment to a later time. If you choose to defer, you have 10 days within which to make that payment. If you don't make the payment within 10 days, you'll get a notice of intent to strike your document for non-payment. So you don't have to pay right away, but it's going to have to be done pretty soon, within 10 days. Question?
So they have, in all of the trainings that I've been in, says that we could pay in cash, cashier's check, or regular check down at the court within that 10-day period. So now you're saying that you cannot do that, it all has to be by credit card?
I take that back. If you're going to pay online, that has to be credit card. You can pay manually if you defer. So the question was to clarify whether all payments, either at the time of e-filing or deferred payments, have to be by credit card. No, I apologize for that, and thank you for the question. All the payments made at the time of e-filing must be done through credit card. If you choose to defer, you can pay in another form at the cashier window. Thank you. Question?
Is the transaction cost going to be chargeable case cost?
We can't comment.
The question is the 2.6% transactional fee going to be awardable as cost? Getting to the advisory opinion area.
Can't hate me for trying.
Yeah.
I also just want to say one more thing. For those of you who might be feeling a little overwhelmed and you got hit with a lot of information, we will have a First Circuit Jeff's user guide out there for circuit court civil practitioners. We're finalizing it now. It's close to completion. I'd hope to get it done, but we're still finalizing some information like emails and that sort of thing. So please continue to check the judiciary website, because a lot of what we covered here will be in the Jeff's user guide. So if you feel like you missed anything, you can check the user guide, and hopefully that will answer some more of your questions.
The judiciary website also has a number of training videos, so if you either missed training or you can use a refresher, there are about 6 or 7 videos of the training session, so please feel free to, they're available now as I understand it. It's on the judiciary website, Jeff's training. Okay? I think that concludes our presentation. We're sorry everything went so long, but they were such great questions. Thank you very much for your participation, and good luck.
I don't remember.
Just took me by surprise.
Yeah.
I don't know why anybody was